Ms. Phelps, are you there?
I am, Your Honor. My video is not working. Give me just one moment. Sorry. Oh, can you see me, Your
Good
Honor?
morning. We're here for the weekend in custody arraignment calendar. Today is Saturday, November 8th. My apologies, but we do need to hurry. We have a very lengthy calendar. Just for the record, I am in receipt of all of the documentation that's been provided, and I have reviewed it thoroughly several times. So please be mindful when discussing your arguments. We will go ahead and begin with the first matter of Juan Cinta, followed by Diego Baldwin.
This is Jimena Fini, Certified Court Interpreter Spanish, NVFXP610. Good morning.
Good morning.
Vamos a empezar con la primera causa de Juan Cinta.
We're going to hold on one moment. Good morning. We're here today for first appearance bail hearing.
Buenos días, estamos aquí entonces para la primera comparecencia de su audiencia para ver la fianza.
Probable cause has been found and the public defender's office has been appointed to represent the defendant.
Se ha encontrado que hay motivo fundado y el abogado defensor del abogado de oficio ha sido entonces nominado para que se represente.
Just for the record, the defendant is present utilizing the services of a previously sworn and certified Spanish interpreter.
Para que conste en acta, entonces, el imputado está presente y está siendo asistido por una intérprete jurídica ya previamente juramentada.
I am in receipt of the Nevada pretrial risk assessment, which indicates that the defendant scored as a 10 or a higher risk utilizing that tool.
Okay, yo tengo acá entonces la evaluación previa al riesgo que ya se había hecho anteriormente y salió con un puntaje de 10 o más.
State, are you ready to proceed with the bail hearing?
¿Fiscalía está lista para proceder entonces con la audiencia para fijar fianza?
Yes, thank you, Your Honor. The state's requesting bail in the amount of $5,000.
Sí, su señoría, gracias. La fiscalía está pidiendo una fianza de $5,000.
DAS supervision with testing for controlled substances.
La fiscalía pide supervisión con pruebas para ver sustancias ilícitas.
And no contact with 900 East Commercial Way.
Y que no haya ningún tipo de contacto con el domicilio de 900 East Commercial Way.
The criminal history report the state received appears to be incomplete.
Los antecedentes penales parece ser que está incompleto.
However, I was able to see that he has 10 cases in Reno Municipal Court in 2025 alone.
Sin embargo, veo que él tiene 5 casos pendientes con la municipalidad de Reno solamente en este año.
Those are mostly for trespassing and possession of drug paraphernalia, and there's 4 failure to appear warrants already this year.
Y que él, por entradas ilícitas y también por parafernalia para uso de drogas, y él ya tiene 4 faltas de comparecencia con órdenes de aprehensión.
He has 3 cases out of Reno Municipal Court in 2024, 2 of which had failure to appear warrants.
Él tiene 3 casos con la municipalidad en el 2024 con faltas de comparecencia y órdenes de aprehensión.
And he's had 13 total failures to appear out of Reno Municipal Court since 2019.
Y desde el 2019 él ha tenido 13 faltas de comparecencia con el Tribunal Municipal de Reno.
So due to the risk of future non-appearance and continued criminal conduct,
debido a la falta del riesgo de las faltas de comparecencia y su conducta delictual,
the state's requesting $5,000 bail.
la fiscalía pide una fianza de $5,000.
Thank you, defense.
Yes, Your Honor. I'd be asking for an OR release today with the conditions that the state has mentioned.
Sí, su señoría, yo voy a pedir que lo dejen en libertad bajo palabra de honor con la condición que ha puesto la fiscal.
In speaking with Mr. Cinta, he does not have a residence.
Hablando con el señor Cinta, él no tiene una residencia,
But he is currently working in construction.
pero actualmente él está trabajando en construcción
Soy de Seattle, Washington.
In Seattle?
Soy de Seattle, Washington.
Wait, what?
Soy de Seattle, Washington, no de Reno, Nevada. I'm constantly in Nevada.
Okay.
But I resident.
Let's see. Sorry, Your Honor. So that would be my ask today, is to just release him on his own recognizance with testing and check-ins.
Y bueno, eso es solo lo que pido su señoría, que él salga en libertad bajo palabra de honor con que le hagan sus pruebas y la orden que fijó.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178, the court finds that the state has met its burden by clear and convincing evidence that bail is necessary.
Ok, gracias. Entonces, basándose en los factores que son previos a la evaluación precondenatoria, de acuerdo a la ley vigente de Nevada, NRS 178, veo que la Fiscalía ha dado el peso de la prueba, por lo tanto, vamos a fijar, se considera que la fianza es necesaria.
As there are no least restrictive means that can be imposed in order to ensure the safety of the community or the appearance of the defendant.
Ya que no hay ningún otro medio menos restringido de que vaya a asegurarse de la seguridad de la comunidad y que el diputado comparezca.
Based on the failure to appear, the criminal history, as well as the lack of ties and a significant criminal history.
Y basándose en eso, en sus faltas de comparecencia, en sus antecedentes penales, la falta de comparecencia que él ha tenido.
Bail will be set in the amount of $5,000 bondable with a 10% cash option.
Entonces se va a fijar la fianza a los $5,000, una fianza garantizada mediante bono con un 10% de abono en dinero en efectivo de ese total.
If the defendant is able to post that bail amount, he will be required to be supervised by the Department of Alternative Sentencing.
Si llega a ser entonces de que él pueda pagar esa fianza, él va a estar entonces con la unidad que va a estar evaluando su cumplimiento.
And he must check in with the DAS within 24 hours of release.
Y tiene que entonces venir acá, de una vez que ya salga, tiene 24 horas para presentarse aquí en ese departamento.
I am ordering that he be subjected to random drug and alcohol testing.
Voy también a ordenar que él tenga órdenes de azar de pruebas de alcohol y drogas.
I do find that there's a sufficient nexus based off of the allegations as contained in the probable cause declaration.
Encuentro que esto debido a las declaraciones previas al juicio, entonces que tenemos suficiente motivo para esto.
So, sir, you cannot use any controlled substances or alcohol unless you have a valid prescription.
Señor, usted no puede usar sustancias ilícitas ni alcohol a no ser que sea una receta regulada.
I am also imposing a no contact order with the location of 900 East Commercial Way.
También voy a ordenar de que usted no puede entonces acercarse a la dirección 900 Este Commercial Way.
So you must stay 100 feet away from that location.
Usted tiene que mantenerse alejado 100 pies de ese lugar.
That will be the order of the court, and we will set a 72-hour hearing.
Ok, esa será la orden judicial y vamos a fijar una audiencia para 72 horas más.
Which will be set for November 14th at 9:30 a.m.
Esto será para el 14 de noviembre a las 9:30 de la mañana.
Thank you.
Gracias.
And Madam Interpreter, I believe that includes all of our matters. Thank you so much for being
Thank you
present
so
here today.
much. Thank you. Bye-bye.
Thank you. Diego Baldwin, followed by Ashley Boyer.
Your Honor, also, Your Honor, if we can call next, Mr. Griffiths. Right here. After this one.
Thank
That'd be
you.
nice.
Good morning. We're here today for two separate matters. We're here for a first appearance and bail hearing in RPC 2025-06 4476 and an arraignment and bail hearing in RCR 2025-131509. We'll begin with that case. And sir, do you have a copy of your criminal complaint?
Yes, ma'am.
Is your legal name correctly spelled on line 7 of that document?
Yes, ma'am.
Have you had a chance to read the charges and do you understand what you're charged with?
Yeah. Yes,
Thank
ma'am.
you. We will go ahead and waive a formal reading. And next, just for the record, we will turn to the bail hearing in both of these matters. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So as to the original arrest warrant case, the one he was just arraigned on, RCR 2025-131-509, the state's requesting that the court retain the bail as presently set at the $25,000 DAS supervision with, let me see here. DAS supervision, no contact with the victim, and no firearms or weapons. As to the battery on a protected person case, the state's requesting bail in the amount of $15,000, DAS supervision, and no firearms or weapons. So this is a pretty egregious battery on a protected person case, Your Honor. I won't belabor the facts. I know you read it, but this violence is commensurate with his robust history of non-compliance and violent offenses. 2025, he's got an arrest back in March for contempt. He's got 2 separate arrests for contempt back in 2023. 2022, he's got misdemeanor convictions for domestic battery and domestic battery first and assault out of Sparks Justice Court. In that case, he's had 4 failure to comply warrants. I do believe that he'll be up for an OSC in that case, and the state will likely be seeking revocation. He's got a misdemeanor arrest for contempt in 2022, another misdemeanor arrest for contempt in 2022, and a misdemeanor conviction for DUI. So due to his risk of continued criminal conduct, non-compliance, and safety to the community, the state is requesting that the bail remain as presently set, with the $25,000 on the domestic battery case by strangulation and $15,000 on the battery on a protected person case.
Thank you. And Ms. Phelps, just to confirm, I did not hear you request for a court to impose a prohibition from the defendant using controlled substances or alcohol, and that he be tested for alcohol. That was previously contained in the for the warrant for the conditions. Just want to confirm that you are not requesting that.
So frankly, Your Honor, if I could just have a moment to review the PC sheet in that case, that one's not listed on my docket. I did see it when I was preparing the battery and protected person case, but if I could just have a moment while defense argues to take a look at that.
But I'm not gonna let
You may defense.
Yes, Your Honor. In speaking with Mr. Baldwin, he's lived in this area his entire life. He's also been working at Chewy's for the last 3 months. We were able to contact his mom and confirm that he does live at the 1080 Nevada Street. He can live with her if he is released. Also, he has been living there, it looks like, for 1 year. I understand his MPRA score was an 8. I think the employment and residence would bring that down to more like a 5. I think with that also, any bail amount would be de facto detention, as he can't afford bail as presently set, even in the $25,000 case. So my ask today would be an ode of cognizance release. If you want to ensure safety of the community, I think there can be some conditions fashioned for that, specifically GPS with house arrest as one condition. Also, I think the no contact is appropriate. Also, the DAS and no firearms. And with that, I'll submit, Your Honor.
Thank you. And with respect to testing.
Thank you, Your Honor. So I did just take another look at the PC sheet for the domestic case. It appears he was drinking to excess that evening, according to the named victim. And then he has that misdemeanor conviction for DUI in 2022. So the state would request the testing for alcohol.
Thank you. In RCR 2025-131509, the court will have the bail to remain as set, including all conditions. The court finds that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case, as there are no least restrictive conditions available in order to ensure the safety of the community. I will note that this is based on the facts as presented in the Nevada pretrial risk assessment, even with reduction as discussed by the defense, and the factors as outlined in NRS 178.4853 and NRS 178.498. The court will note that the named victim in this case is, based off the information, is the same alleged victim in a previous case involving violence, as well as I will just note for the record that in RPC 2025-064476, that it is the exact same victim with concerning circumstances. So with all that information in his mind, the likelihood of conviction, the threat to the safety and the danger to the community, and specifically the named victim in this case, bail will remain as set, including all conditions. In RPC 2025-064476, bail will be set in the amount of $10,000 that will be bondable with a 10% cash option. The court does incorporate the same findings of facts in this case, and will note the violence as well in this case. And so based off of that, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. If the defendant is able to post that bail amount, he will be required to be supervised by the Department of Alternative Sentencing and cannot possess any firearms or weapons, as this is an alleged crime of violence. In this case, we will set the 72-hour hearing. And Madam Clerk, when will that be set? Thank you. That'll be November 14th at 9:30 a.m. And then in RCR 2025-131509, Defense Counsel, what hearing are we setting next?
They'll charge you with battery on a protected.
I didn't do nothing wrong.
It's just talking on her already. No, protected.
Defense Counsel, what hearing are we setting next?
Um,
Your prelim.
Your Honor, I didn't speak with him on that.
Thank you. Would you like us to set a speedy preliminary hearing then?
So what does that mean,
yes,
ma'am?
I would say yes.
So,
Yes, sure.
Yes.
Thank you. So that, just to make sure that's clear, he's invoking his right to speedy preliminary hearing.
Correct, Your Honor.
No.
Thank you. If we could please select a date within 15 days.
Your Honor, this is a Department 3 case, so the state would request that we avoid Tuesdays if possible.
I would
Thank
love to do.
So the 15th day falls on Sunday, the 23rd, so we could do Thursday, December 20th.
Wait.
September 20th or November 20th?
November.
Okay. Okay, that works. Thanks. Man.
Dude,
Not real. Firm would be
I'm in control of my court better.
Tuesday, December 18th.
Tuesday, December 18th. That's my next hearing for November.
Yeah, November.
Thank you. That'll be the order of the court, and they were both set for 1:30 a.m. Or sorry, 1:30 p.m. Thank you.
So I have two different.
Defense Counsel, next you wanted Andrew Griffiths, is that correct?
Yeah. Yes, Your Honor.
Thank you. We'll call that matter next, please. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8, which was overridden to a higher risk. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's requesting bail in the amount of $75,000, bondable only, DAS supervision with testing for drugs and alcohol if he's able to post, no contact with any of the subject residences, and victims. So really the basis of this request, Your Honor, is risk to community safety as borne out by the facts of this case with multiple victims. He essentially terrorized a neighborhood. As far as criminal history, he's got, looks like 2 separate arrests for probation violations felony probation violations back in 2021, with misdemeanor conviction in 2021 for resisting. 2018, he's got a felony conviction for possession of a controlled substance, a misdemeanor conviction for obstructing, and a misdemeanor arrest for 2 outside jurisdiction warrants and obstructing. So he has a documented history of non-compliance, a documented history of drug use, and this case, as I mentioned, shows a very high risk to community safety. So the state is requesting $75,000 bail, bondable only, DAS with testing for drugs and alcohol, and no contact.
Thank you. And just to confirm, is it's Thomas Street, correct?
So I believe that's right, Your Honor. If I could just have one moment while defense presents their argument.
Thank you. Defense?
I would just ask for that to be an interim bail. We do have competency concerns. So I wasn't really able to communicate with him and my colleague wasn't. So I would just ask for that to be interim.
Why are you guys next to me? What did I
Thank
do?
you.
What's that?
And yes, Your Honor, it is Thomas Street. Thomas
Thank you.
Street, I'm sorry.
Thank you. Just for the record, based off of the defense's request, we will go ahead and set an interim bail amount, and that will be set in the amount of $77,500, bondable with no 10% cash option based off the nature of the charges. If the defendant is able to post that bail amount in the meantime, I will require that he be subjected to DAS supervision. So sir, you will have to check in with the Department of Alternative Sentencing within 24 hours of release. I am imposing a no contact order with, and you must stay 100 feet away from Thomas Street, as well as Locust Street. So that's all properties on that location. I'm not going to impose the other conditions that were requested. And we will go ahead and set a 72-hour hearing, and that will be set for November 14th at 9:30 a.m. Thank you.
Thank you, Your Honor.
No, where am I going?
Thank you. Next, we have Ashley Boyer, followed by Zion Brantingham.
That's gonna be, okay, that's, I'm probably, okay,
I don't care, no.
okay.
Okay.
So, sorry, Your Honor. I spoke with, Miss Boyer. She essentially refused. I just asked to continue this to tomorrow. As I was
Thank you. I'll
unable.
just note for the record that the defendant has not been appointed to the Washoe County Public Defender's Office, so we will go ahead and address that tomorrow, and based off of the request, we'll go ahead and continue this entire matter until tomorrow morning at 9:30 a.m. Thank you.
Thank you.
7,000.
Oh.
Ms. Phelps, just to confirm, did you ask for 7,500 or 75,000?
75,000.
Thank you. We'll go ahead and change that. I misheard you. So just for the record on Mr. Griffiths, it'll be a 75,000 bondable with no 10% cash option
Okay, thank you.
as an interim bail. Next, we have Zion Branningham, followed by Ashley Cooper. Good morning.
Good morning.
We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has not been appointed to represent you. So, sir, I'm assuming that you were to remain in custody. Approximately how much money do you make per week?
About $750.
Okay, are you still able to receive that income if you are in custody?
No.
Thank you. I do find that you qualify for the services of public defender. So the Washoe County Public Defender's Office will be appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 11 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing? And then just to confirm, what I have is that he was booked under was criminal contempt or failure to obey court order. I just want to confirm that that would not be what he's proceeding under for this case in terms of with Reno Justice Court, as this court did not issue that original order.
So, Your Honor, I don't think it matters which court issued the original order. I think it was routed to us because it is a violation of the law as it's written in the PC sheet, and it occurred at the Washoe County Detention Facility, and so it comes to Reno Justice Court by virtue of where it occurred.
Thank you. So just to confirm, then you were proceeding under the violation of the court order, not criminal contempt, correct?
Yes, Your Honor.
Thank you. Go ahead and please proceed.
So the contempt matter would obviously be something that the Reno Municipal Court can address in that domestic battery case. So Mr. Branningham scores an 11 on the risk assessment. Just basically, he has a lot of criminal history already this year. He's got a pending case for robbery out of this court. He's got a felony conviction out of California already this year for battery with serious bodily injury. Then he's got that domestic battery pending out of Reno Municipal Court. He's also got a pending possession of stolen property out of Reno Municipal Court and a resisting and petty larceny out of Sparks Municipal Court. That's in addition to a lot of other criminal history that he has going back to at least 2022. And so obviously, Your Honor, he's a very high risk of continued criminal conduct and non-compliance. The state's requesting $5,000 bail in this case.
Any conditions?
No conditions are on this case, Your Honor.
Thank you.
Nothing. Am I able to say something? I don't.
So I'm gonna have you speak. I'm gonna have you speak with your attorney first.
How do I already have a contempt of court? I've been in custody the whole time on the battery.
Yeah. Oh, there we go. So Your Honor, we were able to speak with him, Mr. Branningham. He has lived in Washoe County for 3 years, the same residence for 2 years. Most of his family, it seems, moved here 3 years ago. He was working at a warehouse before his arrest and taken into custody. He does have a working phone and email if he is released. My understanding is he already has significant bail that he clearly can't afford. Otherwise, most likely he would be out of custody. So I would just be asking for an OR on this. It looks like he's already got a $50,000 bondable for, as the state pointed out, a robbery. He has $5,000 bondable on the domestic battery that I believe is related to this contempt. So I would, and he's also got another 750 bondable out of municipal court as well. So I don't think any more bail is needed to ensure safety of the community. And with that, I'll submit, Your Honor.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case, as there are no least restrictive means that can be imposed in order to ensure the safety of the named victim in this case. I'll note just for the record, based off of the declaration of probable cause, there is a significant likelihood of conviction, and that it appears that even with the no contact order and being in custody, the defendant is still contacting the named victim in that case. And so based off that information, bail will be set in an amount of $3,000, bondable with a 10% cash option if the defendant is able to post that bail amount. I'm not requiring any supervision as that was not requested. However, I am requiring that he be subjected to, in this case, as well as the no contact order with the named victim of Buckley Priscilla. So that'll be the order of the court, and we will go ahead and set a 72-hour hearing, and that'll be set for November 14th at 9:30 a.m. Thank you.
Thank you, Your Honor.
Just sit back for you.
Ashley Cooper, followed by David Olson.
So, Your Honor, I did speak with Ms. Cooper. She did waive her appearance, but we can proceed this morning.
Thank you. Unfortunately, the Public Defender's Office has not been appointed to represent her. Do you have any information indicating that she qualifies for the Public Defender's Office?
Well, Your Honor, she is not employed. She is homeless, doesn't have an address. I'm certain she would qualify.
Thank you. Based on that information, I do find that she qualifies for the services of public defender, so the Washoe County Public Defender's Office will be appointed to represent her. We are here today for a first appearance bail hearing. Probable cause has been found. The Public Defender's Office has now been appointed to represent her. We will go ahead and waive her appearance for today's proceeding, and I am in receipt of the Nevada pretrial risk assessment, which indicates that she's scored as an 11 or a higher risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's requesting bail in the amount of $5,000 DAS with testing for controlled substances if she's able to post. She scores an 11 on the risk assessment, 2 points for failures to appear. She was also arrested on a failure to appear warrant out of Sparks Municipal Court. This year, she's got a citation for possession of drug paraphernalia out of Reno Municipal Court. That case had a failure to appear warrant issued in it, and a misdemeanor conviction separately for possession of drug paraphernalia out of Sparks Municipal Court. 2024, she's got misdemeanor convictions for possession of drug paraphernalia and failure to appear. And then in 2022, misdemeanor convictions for possession of drug paraphernalia and possession of stolen property. So Ms. Cooper is a high risk of future non-appearance and continued criminal conduct. So the state's requesting $5,000 bail, DAS supervision with testing for controlled substances if she posts.
Thank you, defense.
Yes, Your Honor. So in speaking with her, she's not employed. She is homeless, does not receive government benefits. My ask today would be an OR with IAP transport to an inpatient facility. It seems like most of her criminal history and recent criminal history is due to drug use and substance abuse. So that'd be my ask today, Your Honor.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the appearance of the defendant. But based off of the failure to appear, as well as the higher risk, I do find in the lack of ties to this community, that bail in the amount of $3,000 bondable with a 10% cash option is appropriate. If the defendant is able to post that bail amount, I will require that she be supervised by the Department of Alternative Sentencing. I'm not imposing the testing conditions at this time. However, the court does find that this order will read that the only least restrictive mean that is appropriate would be a direct transport to an appropriate treatment facility. And so this order will read bail or an OR to an appropriate treatment facility through DAS, IAP, or DSU. That will be over to the court, and we will go ahead and set a 72-hour hearing, which will be set for November 14th at 9:30 a.m. Thank you.
Thank you, Your Honor.
David Olson, followed by Anthony Benitez Rivera.
Your Honor, can we trail Mr. Olson?
Thank
To
you. We'll
the
go ahead and trail Mr. Olson. So we'll go ahead and call Anthony Benitez Rivera, followed by Michael Riano.
Thank you.
Good morning. We're here today for first appearance, or sorry, for a bail hearing. Probable cause has been found. The public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 3 or a low risk utilizing that tool. State, are we prepared today to proceed with the bail hearing?
Yes, thank you, Your Honor. So we continued this matter from yesterday for victim contact. We were able to get in touch with the victim's father, and we learned that the victim's actually 14 years old. I don't think that that was mentioned in the probable cause sheet, and the victim's dad definitely wants a no contact order. So really what tips the scale for me, Your Honor, in asking for bail is that the victim is a 14-year-old child. I understand the defendant's 19 years old. It would make a difference to me if this were someone who were 18 years old or even 17 years old, but this is a 14-year-old child. And so due to the level of violence inflicted on this child, the state is requesting bail in the amount of $20,000, DAS supervision, no contact with the victim, and no firearms.
Thank you. And do you have any additional information as to why a no contact order or GPS monitoring would not be least restrictive means in this case?
No, Your Honor, I'd leave that to defense to argue that.
So you don't have, okay.
I have no information about anything other than what's contained in the probable cause declaration and from the victim's father, who just relayed that he is concerned for his son's safety and wants a no contact order.
Thank you. Defense?
Yes, Your Honor. So in speaking, we did speak with Mr. Benitez yesterday. It looks like he's been in Washoe County his whole life. He does have a verifiable address. As you pointed out, his NPRA score is a 3. Looks like this is his first arrest ever. It looks like he's also employed as a full-time butcher at Safeway. He's been doing that for 4 years. We were able to verify his phone number, also the address. So really, I think his score would just be a 2 based on his age at first arrest, which is this arrest. So we were able to confirm also with his mother all that information that I had just talked about. His mother also stated he's never been in trouble before in his life. So I think there are some conditions that can be fashioned to ensure safety of the community. I think his failure to appear, there's nothing to suggest that he wouldn't appear in court. So I think it's really safety of the community. As you pointed out, I think there could be a GPS if you feel that's appropriate, kind of an obviously no contact order, stay away order. I think that GPS would ensure that if there's an area that he can't go, would ensure that he doesn't go there. I think any other conditions that you would find appropriate as well would be satisfactory. And with that, I'll submit, Your Honor.
Thank you. Based on the facts presented, the court does find that the state has not met its burden by proving by clear and convincing evidence that bail is necessary in this case. So the defendant will be released here today, sir. You will be required to be supervised by the Department of Alternative Sentencing. So I am granting your unrecognizance release. You will be required to check in with the DAS within 24 hours of release. I am imposing the condition that you be subjected to residential confinement with a GPS monitor that must be installed within 24 hours of release. And just for the record, it could be a GPS monitor or a V-check GPS monitor. Either would be approved by this court. So you will be required to be subjected to that. And so just, Madam Clerk, I apologize. I don't recall if I said it, but that can be installed within 24 hours of release. And you are to have no contact with the minor child with initials BM. And so you must stay 100 feet away from that individual as well as his residence, just to make sure that is clear for the record. I am requiring that you appear for your arraignment, which will be on November 25th at 9:30, or sorry, at 9 a.m. Thank you.
Thank you.
Michael Riano. Followed by Aaron Kepler. Good morning. We're here today for an arraignment and a bail hearing. Just for the record, let's go ahead and turn first to the criminal complaint. Do you have a copy of your criminal complaint?
Yeah.
Is your legal name correctly spelled on line 7 of that document?
Yes.
Have you had a chance to read the charge and do you understand what you're charged with?
Yeah.
Thank you. We will go ahead and waive a formal reading and we will turn it to the bail hearing. The court is in receipt of the Nevada pretrial risk assessment, which does indicate that the defendant scored as a 14 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So as Your Honor noted, the
Okay.
defendant does score a 14 on the risk assessment. He was scored 0 points for failures to appear, but he has 2 failure to appear warrants out of Story County. So his score should be a 16 by my math. He noted he has nowhere to live other than with the victim. This is the same victim as the same victim as at least 3 other prior cases, 2 of those out of Reno Municipal Court in 2023 and 1 of those out of this court in 2023. So he's got felony bench warrants issued in 2024, 2 of those out of Story County. 2023, he's got the felony conviction for domestic battery by strangulation. He was sentenced to 12 to 48 months in prison. He had a separate felony case for possession of stolen property dismissed as part of negotiations. He's got a misdemeanor conviction in 2023 for domestic battery second out of Reno Muni, a misdemeanor arrest for domestic battery second out of Reno Muni. That one was dismissed without prejudice. His substance abuse evaluation opines that from 2023 opines that he had or has severe amphetamine use disorder, opiate, cannabis, and alcohol use disorder. His 2023 PSI shows 4 prior felony convictions, 2 prior gross misdemeanor convictions, and 11 prior misdemeanor convictions, including a 2023 misdemeanor conviction for violating a domestic violence protective order, misdemeanor conviction for possession of drug paraphernalia in 2023, gross misdemeanor conviction for attempted possession of controlled substance in 2019. He had a pretrial failure to appear warrant issued in that case. 2018 misdemeanor conviction for domestic battery first. That was out of Reno Municipal Court. That case involved a different victim. He had a failure to comply warrant issued in that case, and his suspended sentence was ultimately revoked. A gross misdemeanor conviction for conspiracy to commit grand larceny in 2017. Felony conviction for robbery in 2012. Felony conviction for assault with a deadly weapon in 2009. Another felony conviction for robbery in 2001. His parole was revoked in that case, and a felony conviction for possession of controlled substance in 2000. So clearly, this defendant is a very high risk of continued criminal conduct, especially as it relates to his intimate partners. He was just convicted a couple years ago on a felony domestic. So the state is requesting $100,000 bail, DAS with testing for drugs and alcohol if he's able to post, no contact with the victim as a condition and pursuant to statute, and no firearms or weapons.
Thank you. Defense?
Yes, Sharon, I would be asking for $10,000 bail, as that ensures safety to the community and his return to court. As the state had pointed out, he does have a lengthy criminal history, so I'd be asking for that $10,000.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. And we'll note, just for the record, also the safety of the named victim in this case. Based off of the likelihood of conviction, the history of non-compliance, the history of violence, and the history of violence involving the same victim, the court does find that bail should be set in the amount of $30,000 that is bondable with no 10% cash option. Based off of the charge, I do find that is appropriate. I am imposing that if the defendant is able to post that bail amount, that he be required to be supervised by the Department of Alternative Sentencing. So sir, you must check in with the DAS within 24 hours of release. I am imposing the condition that you cannot possess any firearms or weapons, as this is an alleged crime of violence. And I am imposing a no contact order with the named victim of Melanie Sayers, Griewe. And so just for the record, you cannot contact him, stay 100 feet away from the victim, cannot contact or attempt to contact the victim in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent. I mean, someone working on your behalf. If you violate this order, just for the record, it is pursuant to this order, as well as pursuant to NRS 178.4845 for a period of 120 days. If you violate this order, you could be charged with a misdemeanor found in contempt pursuant to NRS 22.010. Have these conditions modified, have your release revoked, be remanded into custody, and or any other legal punishment. That will be the order of the court, and we will go ahead and set the next appropriate hearing. Defense counsel, what are we setting next?
Yes, Your Honor, we would like to set a speedy prelim.
Thank you. We'll note for the record that he is invoking his right to a speedy preliminary hearing, and so we will go ahead and set an appropriate date, and just, Madam Clerk, if we could please set a hearing within 15 days, and I'm sure that the parties are in their quest to avoid a Thursday if possible.
That's correct, Your Honor. Thank you.
Yes, Your Honor.
We're gonna go Friday, November 21st at 1:30.
Thank you. That'll be the order of the court, and we'll go ahead and set then that mandatory status conference, which will be a motion to confirm. And Madam Clerk, when will that be? On Thursday.
To Thursday, November 13th.
At 1:30 p.m. Thank you.
Thank you, Your Honor.
Aaron Kepler, followed by Keith Baugh. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's requesting bail in the amount of $5,000 for Mr. Kepler. I have on here to request DAS with testing for drugs and alcohol, but I believe he is on probation with pretrial services supervision, or excuse me, I think it actually might be PMP supervision. So he scores an 8 on the risk assessment, as you noted. He's got a hold for a probation violation. So this year he was convicted by a jury of possession of a controlled substance, but he was granted diversion at sentencing by the court. He did have 2 pretrial violations for positive tests in that case, but it's my understanding he was otherwise compliant. He's got a misdemeanor conviction for resisting also in 2025. I believe those both arose from the same facts or circumstances. And if memory serves, I believe that was a 2021 or a 2022 case. Then he's got a 1998 misdemeanor conviction for DUI. So he doesn't have a whole lot of criminal history, but he was just granted diversion this year. And now he's picked up these new felony charges. So the state is requesting $5,000 bail with supervision commensurate with his other case.
Thank you. So supervision commensurate. So are you requesting pretrial services or parole and probation?
Well, so I believe it's parole and probation, Your Honor.
Thank
Since
you.
it's diversion, I'm not sure, but since he's got a PMP hold, I think it must be the division.
Thank you. Defense?
Yes, Your Honor. I'd like to first point out his MPRA score is a little bit higher than what it should be. He does live here. He was born and raised here in Reno. He does currently live at 1765 East 4th Street. We were also able to speak with his reference. We also confirmed he's employed at Northwest Systems and his phone number. So I think his score mostly would be like a 4 or a 5, which would put him in the low to mid category. In speaking with him, I would just ask for an OR release. It sounds like he's going to have that PMP hold, and if they do lift that hold, clearly he's still going to be supervised. So I think that ensures they have the ability, obviously, to put any sort of conditions on him that they deem appropriate. So I would just ask for an OR release so that he can at least talk with his probation officer to figure out if they're going to lift that hold or what's going to happen with that. It also looks like, this was based on a home check. And they found some drug paraphernalia and some drugs. So with that, I'll submit, Your Honor.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So the defendant will be granted an own recognizance release here today. I am requiring, sir, that you be supervised by the Division of Parole and Probation, so you must check in within 24 hours of release. You will be required, pursuant to this case as well, to be subjected to random drug and alcohol testing. I do find that there is sufficient access, so you cannot use any controlled substances or alcohol unless for a valid prescription. Just to make sure it's very clear, you must be tested a minimum of 2 of every 7 days of the week, including weekends and holidays. And we will go ahead and we'll go ahead and just set an arraignment at this time. And if that needs to be modified, defense counsel can appropriately notify the court, and that will be set for November 25th at 9 a.m. Thank you.
Thank you, ma'am.
Contact appeal.
Keith Baugh, followed by Sarah Dixon. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6 or a higher risk utilizing that tool. And just for the record, it was overridden. And we'll go ahead and to that higher risk. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's not objecting to an own recognizance release, DAS supervision, no contact with Shannon Renfro, and comply with any conditions imposed by CPS.
We'll submit on that, Your Honor.
Thank you.
Thank you. Based off that, the court will grant an own recognizance release. So sir, you will be required to be supervised by the Department of Alternative Sentencing. You must check in with DAS within 24 hours of release. I am imposing a no contact order with Shannon Renfro. And state, what was the other condition?
Comply with CPS.
Thank you. So the court will order that you comply with all orders from the Human Services Agency. That's HSA, otherwise known as CPS. And we will go ahead and set your arraignment date. And that will be set for November 25th at 9 a.m. Thank you.
Thank you.
Next, we have Sarah Dixon, followed by Raylene Fowler. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6 or moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's not objecting to an own recognizance release. I am requesting DAS supervision with testing for drugs and alcohol. She does have misdemeanor convictions for DUI first and second in 2022 and 2023 respectively. And I would also request no contact with Diego Baldwin.
We'll
Thank you.
submit.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So you will be granted an own recognizance release. I will require that you be supervised by the Department of Alternative Sentencing. And you must check in within 24 hours of release. I am imposing the condition that you cannot contact the named victim in this case of Diego Baldwin. And state, can you confirm, is this the one where there is, I believe that we are also seeing Diego Baldwin, is that correct?
That's correct, Your Honor.
Thank you. So just to make sure it's clear of, you are not requesting is we don't have that information for the resident, so just for the named victim, correct?
That's correct, Your Honor. And we already saw Mr. Baldwin this morning.
Thank you. That was my recollection. I just wanted to confirm. So that is the order of the court. I am not imposing the condition that she be subjected to random drug and alcohol testing. I do not find that there's a sufficient nexus. We will go ahead and set an arraignment, and that will be set for November 25th at 9 a.m. Thank you. The defense counsel, just make sure to speak to your client regarding that no contact order. Raylene Fowler, followed by Antonio Reese. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which was overridden to a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's not objecting to a known recognizance release for Ms. Fowler, DAS supervision, no firearms or weapons, and no contact with the McDonald's on Plum Lane.
We'll submit on that, Your Honor.
Thank you. I am granting an own recognizance release if there are least restrictive means that can be imposed in order to ensure the safety of the community as well as your appearance. You will be required to be supervised by the Department of Alternative Sentencing, so you must check in with DAS within 24 hours of release. I am imposing the condition that you cannot possess any firearms or weapons based off the allegations. I do find that that is appropriate. And it is an alleged crime of violence. Additionally, I am imposing the no contact order as requested. So you're to have no contact with the McDonald's at that location. That will be the order of the court, and we will go ahead and set a arraignment, and that will be set for November 25th at 9 a.m. Thank you.
Good luck.
Thank you very much.
Antonio Reese, followed by Kyle Whitaker. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 9 or a higher risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's requesting bail in the amount of $150,000 bondable only. DA has supervision with testing for drugs and alcohol. If he's able to post that, no contact with the victim as a condition and pursuant to statute, and no firearms or weapons. Mr. Reese previously scored a 9 on the risk assessment. This is an ad book. He also has a PNP hold, a hold on a domestic battery out of Reno Municipal Court with the same victim, and he's in custody on additional felony charges that are pending arraignment in justice court. So 2025, he's got a felony arrest for eluding and possession of a controlled substance 14 to 28 grams. That's the case that's pending in CR 25-2491. His district court arraignment is set for November 17th in that case. 2024, he's got a felony conviction for pandering. He's on probation with 19 to 48 months underlying. That's case number CR 22-4471. In that case, he failed to appear for his arraignment in district court. He told the court that he couldn't afford to come to Reno to attend, but then he was arrested in Reno weeks later on a traffic offense. That was a joint recommendation for probation. I would note that the case went to Judge Freeman in Department 9 to cover sentencing, and he sent it back to the original department because he didn't want to sentence to or put this defendant on probation. 2022, he's got a misdemeanor conviction for accessory out of California that was reduced from a felony. 2014, a misdemeanor conviction for forging, handwriting, etc. out of California. 2010, he's got a federal felony conviction out of California for unlawful transport of firearms. Looks like he was sentenced to prison for 46 months. And 3 years of suspended release. He had a probation violation in 2014 and another violation in 2016. 2009 felony conviction for possession of cocaine base for sale out of California, and 2007 felony conviction for transport or sell a controlled substance out of California. He also has juvenile history as well. So as I mentioned, Your Honor, really the main thing here is that he has pending felony charges in district court, and he was convicted of pandering last year and was given an amazing opportunity at probation. And Your Honor read the facts of this sheet. The victim in this case, you know, it's very clear that she's trying to live a clean, healthy life, but he just kept convincing her, oh, I need money for shoes. I need money for a car. Give me money, give me money, give me money. Oh, I love you. Oh, I don't love you. I hate you. So it's just very manipulative. The state is requesting $150,000 bail bondable only. DAS with testing for drugs and alcohol, no contact with the victim as a condition and pursuant to statute, and no firearms or weapons.
Thank you. Defense?
Yes, Your Honor. So, as you pointed out, or as the state pointed out, he does have a current bail set for $20,000 for an eluding. He has a $3,000 hold. So any sort of monetary bail would be de facto detention. My ask today would be to set this at $10,000 with all the conditions that the state recommended. That's just based on his criminal history. I don't think he's appropriate for an OR, and the fact that he does have a second judicial district court hold with these other cases. And with that, I'll submit, Your Honor. Thank
you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.453 and NRS 178.498, the court does find the state has met its burden by proving by clear and convincing evidence that bail is necessary in order to ensure the safety of the community. I will note the history of violence involving the same victim, the history of non-compliance, the history of non-appearance, the history of similar offenses. With that all in mind, is that he's pending cases while this is alleged to have occurred. The court is imposing a bail in the amount of $60,000 bondable with no 10% cash option. If the defendant is able to post that bail amount, I will require that he be supervised by pretrial services. So we must check in with pretrial services within 24 hours of release. I am imposing the requirement that Mr. Reese cannot possess any firearms or weapons, as this is an alleged crime of violence. I am also imposing the condition that he's to have no contact with the named victim of Tylee Zimmerman, and that is pursuant to this judicial release order, as well as pursuant to NRS 178.4845 for a period of 120 days. So you cannot contact him, must stay 100 feet away from the named victim, cannot contact or attempt to contact the victim in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. If you violate this order, you could be charged with a misdemeanor, found in contempt pursuant to NRS 22.010. Have these conditions modified, have your release revoked, and be remanded to custody and or any other legal punishment. That will be the order of the court, and we will go ahead and set a 72-hour hearing, which will be set for November 14th at 9:30 a.m. Thank you. Kyle Whitaker, followed by Jennifer Maldonado Contreras. Good morning. We're here today for first Kyle Whitaker. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which was overridden to a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's not objecting to an own recognizance release with DAS supervision and no contact with the victim Trevor Gibson or his residence at 1370 Peavine Road, and no firearms or weapons.
We'll
Thank
submit on
you.
that.
Thank you. I do find that there are least restrictive means that can be imposed. So Surrey will be granted an own recognizance release. I am imposing the condition that you be supervised by the Department of Alternative Sentencing. So you must check in with DAS within 24 hours of release. You are required to not possess any firearms or weapons, as this is an alleged crime of violence. And I am imposing a no contact order with the named victim in this case as Trevor Gibson and his residence at 1370 Peavine Road. That will be the order of the court. And we will go ahead and set we'll set an arraignment, which will be set for November 25th at 9 a.m. And just to make sure it's clear, you cannot contact him and stay 100 feet away from the victim and his location, cannot contact or attempt to contact him in any way, including a phone, text, email, in person, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. That will be the order of the court, and we will see you back here on your arraignment on November 25th at 9 a.m. Thank you. Next, we have Jennifer Maldonado Contreras, followed by Angelo Salapo. Good morning. We're here today for our first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 5 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's not objecting to an own recognizance release with DAS supervision, no contact with the named victim, and comply with CPS.
We'll submit on that, Your Honor.
Thank you. Based off of the information provided, I do find that there's the least restrictive means that can be imposed in order to ensure the safety of the community. So you will be granted an own recognizance release here today. I am requiring that you be supervised by the Department of Alternative Sentencing, where you must check in with DAS within 24 hours of release. I do find that that is appropriate given the facts and circumstances as alleged in order to ensure the safety of the community. I am imposing the condition that you are to have no contact with the named victim in this case, and we'll just note for the record that unless that is authorized by HSA, you will be required also to comply with all requirements of HSA or the Human Services Agency, otherwise known as CPS. We will go ahead and set your arraignment, so you must appear in Reno Justice Court on November 25th at 9 a.m. Thank you.
Thank you.
Angelo Salapo, followed by Shannon Renfro. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 7 or moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. The state's not objecting to an own recognizance release, DAS supervision, no contact with the victim. And I should have clarified on the last one, Your Honor, this is the co-defendant, the victim being the domestic victim. So that in this case, that would be Jennifer Maldonado Contreras, and then comply with CPS.
We'll submit on that, Your
Thank you.
Honor.
So just to confirm, hold on, defense, my apologies. So just to confirm, you have no issues with the defendant having contact with the biological children.
That's correct, Your Honor, as long as it's authorized by CPS.
Okay, so that's different. Thank you. Defense?
We'll submit on that, Your Honor.
Thank you. I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community, so the defendant will be released on his own recognizance, or he will be required to be supervised by the Department of Alternative Sentencing and must check in with DAS within 24 hours of release. I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. And I do find that that is necessary. You will be required to have no contact with the named victims in this case, just to make sure it's clear it's all the named victims with respect to the biological children that will be based on HSA or the Human Services Agency allowing for that. You will be required to comply with all HSA requirements, and we will go ahead and set the arraignment, which we set for November 25th at 9:30 a.m. Thank you.
Thank you.
Shannon Renfro, followed by Robert Limley. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6 or moderate risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, Your Honor, the state's not objecting to an on-recognizance release from Ms. Renfro with DAS supervision with testing for controlled substances and comply with CPS.
Thank you. Are you requesting a no contact order?
Just to the extent that she's prohibited from contact by HSA. So no contact unless authorized by CPS.
Thank you. Defense?
Yeah, we'll submit on that, Your Honor.
Thank you. Based off the information provided, I do find that there is least restrictive means in order to ensure the safety of the community, so you will be released on your own recognizance. I am requiring that you be supervised by the Department of Alternative Sentencing and must check in with DAS within 24 hours of release. I do find that that is appropriate. I am imposing the no contact order with a minor child unless authorized by the Human Services Agency, otherwise known as HSA or CPS. You will be required to comply with all requirements of HSA. I am also requiring that you cannot use any controlled substances or alcohol unless you have a valid prescription, be subjected to random drug and alcohol testing. I do find that that is necessary in order to ensure the safety of the community and the named victim. We will go ahead and set a arraignment date, and that'll be set for November 25th at 9 a.m. Thank you. Robert Limley, followed by David Olson.
Your Honor, I believe Mr. Limley was a fugitive.
Yes, so is he there?
He was here. He actually went back to, but I think we can proceed if we're ready. The state's ready.
So are you waiving his appearance? Is the jail waiving his appearance? Can we just continue
Yes.
this until tomorrow?
Yes, Your Honor, we're waiving his appearance.
Thank you. We'll note that for the record, we have his appearance. Probable cause has been found. We will set a 72-hour hearing, which will be set for November 14th at 9:30 a.m. Thank you.
Thank you.
David Olson.
Yes. Morning, Your Honor.
Good morning. We're here today for a bail hearing. Just for the record, I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a moderate risk. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So I've got kind of a lot to go over with regard to Mr. Olson's case. So he scores a 5 on the risk assessment, but I think that really is not an accurate reflection of the risk that he poses based on the criminal history and other evidence that I see. So first, I just want to remind the court generally of the facts of this case. I know Your Honor read it. The defendant tortured a little dog repeatedly over a period of days and recorded himself doing it to inflict psychological torture on his ex-girlfriend, who reportedly has a cognitive developmental disability and was desperately trying to get away from him. He essentially wrapped this case up in a bow by capturing the depravity on video, which he laughed about, by the way, when confronted by officers. And I do believe that a jury will swiftly convict him of these charges. I believe the likelihood of conviction is very high. A detention order is appropriate for this defendant based on the facts of this case that I just discussed, the likelihood of conviction I just discussed, his risk of future non-appearance, which I'll get into, and his criminal history, which involves a lot of violence against women, which I'll also get into a moment. But so when I'm thinking about what amount is needed for a detention level bail, I usually don't have a lot to go on. But in this case, I actually was able to find Mr. Olson's Facebook page, which kind of gives some insight into his financial ability to post bail. He posted multiple pictures of what we call bands of $100 wrapped into $10,000 increments. I see 3 of those in one picture with numerous other $100 bills. I see a picture with $100 bills strewn all over the alleged victim in this case. And he also has a very nice truck with a nice camper trailer. So he appears to have significant financial means. As far as criminal history, and I would also just note that that Facebook page is in the name of David Olson. There's numerous pictures of him and the named victim posted to that account. As far as criminal history, he has a non-extraditable warrant out of Wisconsin for domestic battery. 2023, he's got a misdemeanor arrest for domestic battery and CCW out of Wisconsin with no dispo. That appears to be the case for which he's got a warrant. 2022, a misdemeanor conviction for contempt out of California, a misdemeanor arrest for contempt out of California with no disposition. That arrest occurred 4 days after his misdemeanor conviction for attempt, so it was separate. 2021, a felony arrest for assault with a deadly weapon and domestic battery out of California with no disposition. 2020, a misdemeanor arrest for battery on a protected person out of California with no disposition. 1996, misdemeanor convictions for domestic battery, 2 counts, and a battery conviction out of California, a misdemeanor conviction for petty theft, misdemeanor conviction for being under the influence of controlled substances. 1995, a misdemeanor conviction for battery out of California. He was also arrested for domestic battery in that case. 1994, a felony arrest for domestic battery and burglary out of California with an unknown disposition. And 1992, a misdemeanor conviction for domestic battery. So by my count, that's 1, 2, 3, 4, 5, 6, 7 arrests with convictions, with several convictions in the past 30 or so years. I also did find some things on his Facebook page that really kind of go to the level of violence that that he poses to intimate partners. He posted a meme on his Facebook page that says, "Seeing an ex in your dream is called," and he wrote, "As long as she's falling down a flight of stairs and surviving as a paraplegic, I welcome seeing her in my dreams. XOXO, Mrs. Veronica Lucinda Olson." He made another post, and this I think goes to maybe the pending domestic battery out of Wisconsin. "To whomever this may apply, namely one lying nasty hoe tramp with a V&O in her legal name. See you soon when the Sixth Amendment will put you eye to eye with me." So, what we have here is a defendant who has a decades-long history of abusing intimate partners. As I mentioned, in this case, we have an alleged victim who is reported to have a severe cognitive disability. And then we have an innocent victim, that being the little dog, who really can't protect himself at all. And this defendant thinks it's funny. And frankly, I think he's a very high risk of continued criminal conduct. I think he's a very high risk of safety to this victim. And I think that this court needs to impose a detention level bail. And based on his resources, I think that amount needs to be very high. So the state's requesting bail in the amount of $150,000, bondable only, DAS supervision if he's able to post that, no contact with the victim as a condition and pursuant to statute, and no firearms or weapons.
Thank you, defense.
Yes, Your Honor. So we were able to contact his sister, Sandra. She stated that he has lived, I guess, in this area for 5 to 6 years. He does live at 1455 West 4th Street, number 99. We did confirm that. It was also confirmed by her that he's not currently working and he has been living off of inheritance in the past, but also that he is currently on food stamps and Medicaid. So I think the state's kind of judgment on whether he can afford or not. I think, social media is not usually reality. We're not sure if these are actual pictures or if it's just pictures. I know people like to, paint their life as perfect or like they have money on there. I don't think that normally lines up with what's actually happening in reality.
By money.
So, so I think the NPRA score is correct. The employment, as I stated, he's not currently employed. It seems like he does have a prior criminal history, but I think there are some conditions that can be fashioned to ensure safety to community, specifically safety to the alleged victim here. I think one of those would be GPS monitoring. With a stay away or no contact order with the alleged victim in this case. There's nothing to say that he won't appear in court. It sounds like there was that I think alleged threat that but that's just, for me, that was just saying, hey, I'll see you in court. Sixth Amendment, it's a confrontation clause. So I think that ensures he will actually return to court. It seems like he was going to in that case with whatever happened there. So Your Honor, with that, I would ask for a nominal bail, if not an over release with GPS.
Oh, hard. Yes.
Yeah, and with that, I'll submit, Your Honor.
Thank you. Based off of the facts as presented, the Nevada pretrial risk assessment, the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that a detention order is appropriate in this case. Given all the facts and circumstances, the likelihood of conviction, the extended period of time or which this alleged acts of violence have occurred, not only to the named human victim, but to the animal as well. The history of violence, as discussed, the history involving history of violence towards women, the outside jurisdiction, criminal conduct. And I will just note for the record regarding the financial ability, I will note the information stated by the defense is what he indicated is that he survives off of at least what was included EBT. I will just note also the concerns regarding that he has access to money. There's discussion, including the declaration supplement that he was able to provide, or we'll just note that he has spent all this money and that I have to make it back for him according to the named victim, and he's going to leave me alone until he gets this 30 grand. The court has some information that he had access to 30 grand. I'll just also note that he had regarding, I don't know if it's real or fake, but pictures involving money indicating that potentially he had access to cash, significant amount of cash, as well as to his vehicles. I do find that the state has met its burden, and that a detention order, as I indicated, is absolutely appropriate and necessary in this case. Bail will be set in the amount of $150,000 that will be bondable with no 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by the Department of Alternative Sentencing and must check in with DAS within 24 hours of release. I am imposing the condition that he cannot possess any firearms or weapons, as this is an alleged crime of violence. I am imposing the condition he cannot contact the named victim in this case. I want to make sure that it's very clear that is pursuant to this judicial release order, which remains until it is lifted, as well as pursuant to NRS 178.4845 for a period of 120 days. The defendant cannot contact him, must stay 100 feet from the victim, cannot contact or attempt to contact the victim in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent and someone working on your behalf. If you're able to, if you violate this order, you could be charged with a misdemeanor found contempt pursuant to NRS 22.010, have these conditions modified, have your release revoked, be remanded into custody, and or any other illegal punishment. Additionally, as this court does not have enough information regarding the defendant's ability to go to animal control and obtain that animal, I just want to make sure it's very clear that he is to have no, he's to not possess or have under his custody or control any animal, specifically dogs. So I want to make sure that is very clear for the record. That is pursuant to, this court does have that ability pursuant to the statute, as well as in order to ensure the safety of the community, as well as all of the named victims in this case. That will be the order of the court, and we'll go ahead and set a 72-hour hearing, and that will be set for November 13th at 9:30 a.m. Thank you.
Thank you.
And I believe that is everyone that I have on my list. Just want to confirm before we conclude today.
That does look to be it, yes.
Thank you, everyone. Have a great rest of your day.
Thanks, Judge, you too, and thanks for the extra time this morning. It was crazy.
Absolutely. I appreciate that. And I appreciate the parties for getting through that as quickly as we could.
Thank you so much, Judge. Have a good weekend, or see you tomorrow.
You too.
Bye.
Bye.